Yes, it is on. Can you hear me? Greg Munson, Mesquite, Texas. Thank you for giving me the opportunity to propose revisions to the board rules and allowing me to address the board regarding my proposed revisions. I believe Laura sent each board member a copy of my proposed revisions. I've also attached a copy for you. I was also informed by Laura that each of you received a copy of the Open Records Decision number 683 that was issued by the Attorney General last November, so I trust that you are all familiar with that ruling. In Open Records Decision number 683, dated November the 24th, 2009, Attorney General Greg Abbott states, Section 801-207B does not prohibit the board from sending a copy of either a complaint to the licensee about whom it concerns or a licensee's response to the complainant during the investigation of the complaint. Currently, Board Rule 57528 addresses the issue of sending a copy of the complaint to the licensee, but it fails to address the equally important issue of providing a copy of the licensee's response to the complainant during the investigation. The proposed revision remedies the situation by having a copy of the licensee's response automatically sent to the complainant as part of the investigation process. Since a copy of the licensee's response is not available to the complainant once an investigation is closed, it is imperative that a copy of the licensee's response is provided to the complainant automatically and promptly during the investigation. The licensee does not have to ask for a copy of the complaint. The complainant should not have to ask for a copy of the licensee's response. Currently, a complainant is allowed to submit to the board any additional relevant information or evidence that may become available after their initial submission at any time during the investigation process. Any response the complainant may have regarding the licensee's response can be submitted to the board in this manner. As a result, there would be no impact on resolution time of a complaint. A licensee who knows that a complainant may never see their response to the complaint could very well be tempted to falsify their response to the complaint, knowing that there will be nobody to dispute their version of events. A complainant may never think to ask for a copy of the licensee's response during the investigation because they do not yet realize that licensees can and sometimes do falsify their responses. By the time that it dawns on them that the licensee must have been less than truthful in their dismissed complaint, it will then be too late to ask for and receive a copy of the licensee's response as the investigation will be closed. A licensee may be much less tempted to falsify their response if they know that a copy of their response will be sent to the complainant automatically. This board is charged with protecting the public. Passing this proposed revision is a step in that direction. Thank you very much.
Thank you, Mr. Munson. Members, I think, and Nicole, again, help me, I'll make sure I don't mistake this. I think where we are at this point in time with this is, number one, it probably should be referred to the Rules Committee. And number two, there is a timeline, as I recall, in the Administrative Procedure Act. Once a petition is received, an agency, I think, must act on it. Is it 60 days?
Just means that they have to start the process.
Start the process?
We've already started the process by having it today, so we're fine.
So I think what staff would like, members, is, I don't know if we need a motion, or we need a motion and a second to refer this then to the Rules Committee. I would imagine that we would then do that and bring it up at the September 10th, most likely. Dr. Carpenter?
I'll make the motion.
To note and second that 575-128 complaints and investigations be referred to the Rules Committee for consideration. Those that are in favor of that motion, please say aye. Aye. Motion carries. Okay. Yes.
I should ask this before we voted, but Mr. Munson, on your aid there, you said that during the investigation, the investigator shall interview the complainant. What do you mean by interview? Versus contact? You scratched out contact and put interview.
Yes, the rule used to be interview, and it was changed to contact here within the last year or so. I believe interview is a much more, a word that should describe the process better. Instead of contacting, I think that they should contact them on the phone and interview them. Not just attempt to contact, but actually interview the complainant and get their version of events in case anything's been missed in what's been submitted.
And Dr. Heflin, Ms. Munson, I don't wish to reopen old wounds by any stretch, but I would observe this is something we certainly want to discuss, and there's merit, I think, to that proposition. I think the flip side is it is sometimes very difficult for the investigator to reach a licensee. And
Well, this is actually the complainant.
okay, excuse me, thank you, I stand corrected. I did mean to say complainant, much less interview them. So that's something I think we can talk about, and we will keep you posted.
And that's not that important of a part of this rule. I would much prefer the other revision being taken care of. I can live without that being done, but that would be a plus to have that changed as well.
We will keep you posted when the next rule committee meeting is, and it might be useful if you are available
Sure.
to attend that,
Sure.
that subcommittee meeting.
Okay.
Let me ask one more question now. Suppose this was granted and you got a copy of the licensee's response, and then you would want to respond to that, correct, if it was incorrect?
If it was untruthful, most certainly, yes.
Would you expect the licensee to respond to what you wrote?
If that's, if they want to, sure.
Well, and that's the one thing that I think we need to guard against is back and forth and delaying, because we already have a backlog.
Okay.
I see value in this. I know where you're going with it, I think, but we got to be careful. We don't get into the he said, she said,
And I can understand that, so you could just put a stop to it right with the complainant being allowed to respond to the licensee's response. I think that would be fair. Because the thing is, in everything that the complainant has submitted, it's only fair that the complainant can see that licensee's response and then respond to that.
Well, the licensee's going to say that he wants to respond to your second.
Well, that's what the
he will
informal
say
conference
that's
is for, I guess. So, I mean, I understand, but the thing is, without the complainant being able to see the licensee's response, there's nobody that can really dispute the licensee's version of events. They can change it any way they want to, and the person with all the knowledge of it, which would be the complainant, is not going to see anything that licensee submits. It's very important that the complainant gets that opportunity.